I invite the next participating delegation, Zambia, to address the court, and I call upon Mr. Marshal Mubambe Mushende to take the floor.
Mr. President, Justice Nawaf Salam, distinguished members of the court, as you have mentioned correctly, Your Lordship, my names are Marshal Mubambe Mujende, State Counsel, and I'm the Solicitor General for the Republic of Zambia. I've come with my team, which includes His Excellency Mr. Sylvester Mundanda, who is the Ambassador of Zambia to the Benelux countries, which includes Belgium, Netherlands, and the Luxembourg. I also have with me the team that is on record with you. Allow me to proceed. Your Lordship, I have the honor and privilege to make a submission on behalf of the Republic of Zambia on the request for an advisory opinion of this court concerning the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its alleged adoption of related discriminatory legislation and measures. My delegation appears before this court as Zambia's unwavering commitment to peace and the principles of international law, which underpin the international system. We recognize the humanity and dignity of all individuals affected by the conflict, irrespective of their nationality or ethnicity. Mr. President, the Republic of Zambia did submit its written statement to the court in July of 2023, and we shall rely on the same. With leave of court, however, allow me to augment with oral submissions which are in support of the written submissions alluded to. Mr. President, we have carefully looked at the question that has been posed to the court, and we submit at the very outset that the Republic of Zambia recognizes the court's jurisdiction to render advisory opinions in accordance with Article 65 of the United Nations Statute. As it did in the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territory in 2004. We, however, make the case that the question posed to the court this time around is more complex and requires Solomonic wisdom to obviate rendering an opinion that may exacerbate rather than resolve the complex and nuanced situation which both Palestine and Israel find themselves. The Republic of Zambia has been consistent and continues to advocate for relentless efforts aimed at achieving peace in the Middle East based on the principles of the two-state solution, and we shall revert to this issue later. Mr. President, Zambia will rely on the following legal framework in making its arguments. That is to say, number one, the United Nations Charter. Number two, the Statute of the International Court of Justice. Number three, let me just say the Oslo I Accord, instead of regurgitating the full citation. Number four, the Oslo II Accord. And number five, we rely on the advisory opinion which this court rendered with regards to the consequences of the construction of the wall in the occupied Palestinian territory in 2004. Number six, we also rely on the United Nations Security Council resolutions 242 of 1967 and 338 of 1973. Mr. President, we recognize the inalienable right of the Palestinian people to self-determination. We also recognize the legitimate security needs of the Israeli people. Both Israel and Palestine have a duty to respect international human rights law and international humanitarian law. Therefore, any recourse to the conflict should not be one that puts the blame squarely on one party, but rather one that advances a negotiated solution that culminates in a two-state solution. May it be on record, my Lord, that our support for the Palestinian people's right to self-determination remains steadfast, echoing our consistent position within the United Nations. However, it is imperative to approach this issue with a comprehensive and balanced perspective. Zambia believes that any declaration addressing the Israeli-Palestinian conflict must acknowledge the complexities and nuances inherent in the circumstances and the need to take serious consideration of the difficult situation that both parties find themselves as they strive to defend the respective rights of their people. Mr. President, sir, the Republic of Zambia is cognizant of the fact that at the center of the conflict is the territorial dispute and rejection of the partition plan since the creation of the State of Israel in 1948. The United Nations has historically attempted to resolve this conflict through political processes, which culminated in various peace treaties and Security Council resolutions, such as the Oslo Accords and the Security Council resolutions 242 of 1967 and 338 of 1973. There is also the historic exchange of letters between the late former Prime Minister of Israel, may his soul rest in peace, Isaac Rabin, and the late former Palestinian Liberation Organization Chairman, may his soul rest in peace, the late Yasser Arafat, dated 9 September 1993. This exchange, Your Lordship, and members of the court, which carries no time limit on its validity, contains mutual declarations of recognition, reciprocal commitments to negotiate peace. To this end, the parties, and I mean both Israel and Palestine, are expected to refrain from undermining or prejudicing the accords through unilateral or third-party initiatives, or actions and from any other initiatives and attempts to impose a solution that seeks to circumvent the agreed upon negotiations. Mr. President, members of the court, there is an argument that negotiations have proved to be ineffective in the past, and therefore the resort to advisory opinions. The Republic of Zambia respectfully submits that the Israelis, the Palestinians, regional states, and the broader international community, and indeed the United Nations Security Council, should consider the reasons why the negotiations failed in the first place and address that issue before resorting to a solution that seeks to bypass the agreed upon negotiations. In the case of the Israeli-Palestinian conflict, if it is established that negotiations have been ineffective, it may call then for an addendum to the Oslo I Accord to amend Article 15, which provides for negotiations, and replace that clause with another mode of dispute settlement. Mr. President, in any event, one may also argue that the advisory opinion by this court on the legal consequences of the construction of the wall in the occupied Palestinian territory in 2004 was also ineffective. Should it then be argued also that the international community must abandon advisory opinions of this court? We submit that postmortems are important in evaluating the challenges and limitations of the dispute settlement mechanisms that are applied to resolve the problem before resorting to another mode. Mr. President and members of the court, it is our firm submission that the Oslo Accords remain the only valid, agreed legal source of authority for the division of control, powers, and responsibilities between Palestine and Israel over the various parts of the territories. Article 15 of the Oslo I Accord prescribes negotiations as the mode of resolving disputes. No other legal or normative framework, whether through international conventions, declarations, or UN resolutions, has substituted the agreed upon, still valid legal framework of the Oslo Accords, unless and until the same are amended. Zambia proposes that the final determination of this matter would be for the parties to resolve their dispute through a settlement means of their choice, which is negotiations. The just and sustainable two-state solution cannot be imposed from the outside through an advisory opinion. The Republic of Zambia fully supports this recognized and established framework for the resolution of the Israeli-Palestinian conflict. The court needs to safeguard the established legal framework as endorsed by the parties' bilateral agreements and reflected in repeated United Nations resolutions, both with respect to the administration of the territory pending a negotiated outcome, and with respect to reaching a permanent status solution or resolution that addresses legitimate needs and aspirations of both sides. The parties have an obligation under Article 31, Clause 7 of the 1995 Palestinian Interim Agreement on the West Bank and the Gaza Strip, which is Oslo II Accord, not to initiate or take any step that would change the status of the West Bank and the Gaza Strip pending the outcome of the permanent status negotiations. Mr. President, members of the court, this court did announce or pronounce itself on the importance of continued negotiations in its advisory opinion of 2004 on the legal consequences of the construction of the wall in the occupied Palestinian territory. The court encouraged efforts to achieve a negotiated solution to the conflict and the establishment of a Palestinian state existing side by side with Israel for peace and security for all in the region. This court, while noting that illegal actions and unilateral decisions were taken on both sides, confirmed the continued validity of the legal framework by stipulating that this situation can be ended only through implementation of the agreements in good faith. Mr. President, members of the court, as we conclude, we wish to submit that the court is neither the only dispute resolution mechanism available, nor is it the best in all circumstances. Let me repeat that one. As we conclude, we wish to submit that the court is neither the only dispute resolution mechanism available, nor is it the best in all circumstances. The best dispute resolution mechanism is one that delivers optimal and sustainable solutions depending on the peculiar circumstances of each case. And there is certainly no one-size-fits-all. Where, for instance, the objective of the dispute resolution mechanism is to blame one party or the other, or to solely determine a winner or a loser, then we have no doubt that the court is the best forum. Mr. President, those of us that have practiced law for many years know how in determining a winner and a loser, the court decisions have, in almost all cases, left permanently ruined relationships between neighbors on a difference which could have been resolved in a better way by adopting alternative dispute mechanisms such as a negotiated settlement, conciliation, or mediation. In conclusion, therefore, the Republic of Zambia reiterates the call for relentless efforts aimed at achieving peace in the Middle East based on the principles of a two-state solution. Both Israel and Palestine have a duty to respect international human rights law and international humanitarian law. Therefore, any recourse to the conflict should not be one that puts a blame squarely on one party, but rather one that advances a negotiated solution, which culminates in a two-state solution. The Republic of Zambia surmises that the court should not exercise its jurisdiction under Article 65 of the statute but rather give deference and sanctity to the bilateral agreements existing between the two states, and indeed give deference to the doctrine of party autonomy and pacta sunt servanda. We argue in the alternative, we conclude in the alternative that should the court decide to exercise its jurisdiction to render the sought advisory opinion, which, as we said, it has the jurisdiction, then the opinion should encourage and assist the parties to respect the legal commitments, including conducting credible negotiations, and not make it more difficult for them to do so. This is also anchored on the fundamental international legal principle of pacta sunt servanda. In this way, Your Lordship, the court would essentially be upholding the sovereign rights of the two parties. Mr. President, I thank you for your attention.
Do you want to watch more videos like this one? If yes, subscribe to our channel and press the bell icon next to it. We have decided to bring videos on something nobody talks about: African politics, economy, and increasing power.
Thanks for watching the video. Comment, share, and subscribe to Africa's most loved YouTube channel for the more captivating videos.